today's speakers, Senior Attorney at Law, Mr. Arulpragasam, and also Senior Deputy Solicitor General, Dilip P.S. I invite Mr. Arulpragasam, Senior Attorney at Law, to start the session.
I was supposed to start the session in the morning, but now it's in the afternoon. So good afternoon to all of you. No response. Good afternoon. The topic that I have to address you today is the salient features of Power of Attorney Ordinance, Power of Attorney Amendment Act 22 of 2022, Wills Amendment Act of 29 of 2022, Notaries Amendment Act of 31 of 22, and Registration Document Amendment Act of 32 of 2022. So before I commence my topic, I like to give you a brief summary why these amendments were brought in. As you all know, the original amendments pertaining to this act were well over 100 years old. In short, those are all archives ordinance. Just to give you a little example, Wills Ordinance 1884, Power of Attorney Ordinance 1902, Notaries Ordinance 1907, Registration Documents Ordinance 1927. So due to this archives ordinance, which is well over 100 years old, and due to the lacuna in the law and various loopholes in the law, recent past, fraudulent transactions have been tremendously increased. As a result of that, several lawyers have been indicted by the Honorable Attorney General in various parts of the country in high courts. In addition to that, Fraud Bureau has filed several actions against the Magistrate Court against several notaries. In addition to that, I am personally aware, as a chairman of the Professional Purposes Committee, making use of this lacuna in the law, rather loopholes, there are several frivolous complaints are made against the lawyer. So in this background, in this scenario only, former Minister of Justice, present Minister of Foreign Affairs, Honorable Arishab, the President's Counsel, appointed me as a chairman of the committee look into these laws. So basically these laws are brought in short, to eradicate or rather to minimize the fraudulent transaction and also to safeguard innocent notaries against frivolous complaints. So my committee, to assist me, Honorable Minister of Justice, Honorable Arishab, the President's Counsel, appointed a committee, very dynamic, very versatile, with various fields of law. In short, I had members from the Attorney General's Department, Legal Draftsman Department, Minister of Justice, Bar Association, as well as Registrar General's. So we met well over 3 months, more than 20 occasions, and we deliberated, discussed, took the advice from various members of the committee, and we put the final draft and forwarded the final draft to the Bar Association for them to vet it. And subsequently, we gave a, like I can say with proudly, like a masterpiece legislation or a very relevant and pertinent act to today's context to the Honorable Minister. But unfortunately, the act or the recommendation we made were not accepted in verbatim. Some of the amendments, some of the suggestions that we made was totally dropped. Some of the amendments were modified and new amendments were introduced. As a result of that, today is in a, you ask, all these acts are very chaotic situation. I'm sure every one of you would have faced a number of problems last several months. In short, when a deed is tendered to the land registry for registration, various registrars of lands are giving different interpretations. Various lawyers are giving various interpretations. In short, even the Registrar General Office is unable to form or express an opinion. So to avoid this situation, I met the President Minister of Justice, Honorable Dr. Vijay Rajapaksa, President's Counsel. I explained the difficulties faced by the notaries, and I suggested what proposal should have to bring in to avoid this conflict situation there. I hope at least very soon those laws will come into effect. Just to give you a simple example how far they have made this act a mess. Our committee suggested to affix photograph to the protocol to avoid the notary, so to avoid the difficulties faced by the notary. Whereas very often clients will come, sign a deed, and subsequently if there is an issue, they deny and said, I never saw this lawyer, I never came to this office, I never signed. To safeguard the notary, I suggested let the photograph of the parties to be affixed to the protocol. What have they done? Now they have suggested to affix to the original. As a result of that, what happened? Privacy goes. For example, a hierarchy of a country, maybe a high-profile professional, or maybe a politician, or some high-profile person purchase a property through social media, whole country will get to know. Privacy is there. That's one. The second thing is look at the act. The second thing is look at the proposal that we made is in regard to the thumb impression only to the original. Today, each and every document, deed of lease, mortgage bond, executor's conveyance, declaration, everything you have to utter mess. That's second. And the third thing, look at the interpretation, the word that they have given to the executor. What do they say, executor? Parties. The power of attorney ordinance says the person who has to sign the power of attorney is the grantor, not the attorney. Now, owing to this, banks having problem in regard to the mortgages. Whether mortgagor and the mortgagee both have to sign, whether power of attorney both have to sign. Now, take for example, executor's conveyance. If there are 10, 15 beneficiaries, all the beneficiaries have to sign. Why? Due to the interpretation word. Executor in the notary's ordinance has been interpreted as parties. So this is a mess. Anyway, I can go on talking 1 hour of that. I think my good friend Dilip is here to do the more important thing related to the fraud part of it. So I'll stop it. I'll start my lecture. The first one I'll discuss with you, notary's ordinance. I think everybody all got the note, my note. Notaries Amendment Act, I deal with you. First salient feature introduced by the new amendment is, in terms of section 31, subparagraph 17b, it has been mandatory to do a search prior to the execution of a deed. Notaries ආඥාපනතේ 31/17 B වගන්ති යටතේ පැහැදිලිව සඳහන් කරලා තියෙනවා කිසියම් ඔප්පුවක් ලියා සාතික කිරීමට පෙර කළ යුතු පළවෙනි කර්තව්‍ය නැත්නම් කාර්යය තමයි ඉඩම් ලියාපදිංචි කිරීමේ කාර්යාලයේ පොත් පරීක්ෂා කරනවා. ඇයි මේ පරීක්ෂා කරලා බලන්නේ? බැඳීම් තියනවාද කියලා. Whether there are encumbrances. What are the encumbrances? It could be, there could be a caveat, there could be a lispendence, there could be a seizure notice, there can be a priority notice. So to ascertain that only we say. So first and foremost thing is to do a search in the land register. You have to do a search. Not only you have to do a search, having done a search, you have to obtain an extract. හුදෙක් පොත් පරීක්ෂා කර බැලීම ප්‍රමාණවත් නැහැ. අනිවාර්යයෙන්ම පත්තිරුවේ සහතික පිටපතක් ලබා ගත යුතුයි. Assume for a moment that you do a deed today and you tender the deed for registration. In the meantime, a caveat has come. But if you have obtained an extract, you can escape. Why? I have done a search. Here is the last entry when I did it. So all these are introduced to safeguard the notary. That's the first thing. The second thing is, in section 31, subparagraph 17(2), there was a provision earlier, search dispensed with. ඉඩම් කන්තෝරුවේ පොත් පරීක්ෂා කිරීම අවශ්‍ය නැහැ. Now this is a problem. If you Dilip will address you on that matter. If you take 99.99 fraudulent deeds, there is endorsement. Say, search dispensed with. Who is the fool who paid hard-earned money to a client, to a lawyer and said, sir or madam, look at this deed, and I will say, don't check the land register. No. When a lawyer is doing a fraudulent deed, he take this safeguard to safeguard himself and say, I didn't do a search. Why? There's a specific instruction from the client to not to do a search. Now, to avoid that fraudulent situation, we have now deleted. No longer search dispenses you can't. It is mandatory for you to do a search in the land registry. Number one, you have to do a search. Number two, you have to obtain an extract, the last entry. Not only the last extract, having obtained the last extract, when you are tendering the deed for registration, you have to put the last prior registration number, volume folio. Earlier, when you give a deed for registration, they accept. Any rubbish they accept, as long as the stamp duty is paid. Now, no. Now at the counter it's rejected. So you have to be careful. So you have to insert this. So that is section 31, subparagraph 17b. The next one, the second salient feature set out in section 31(15)(a), 1a, is in addition to the signature, thumb impression of any hand is to affix in the above or beside the signature executed the original duplicate or protocol. So now all these years from 1907 up to 2012, 1st of November, the law was when you execute a deed, all what you did is got the signature. Now apart from the signature, you have to get the thumb impression. Where do you put the thumb impression? Beside or above the signature. That's a mandatory. Generally the practice is that you adopted it, left thumb impression. Now the act says any thumb impression. Then that is the second bit. Then the third one, there are couple of categories of deed where you have to affix photograph. That is in terms of section 31(17)(b)(3). Notaries ආඥාපනතේ 31(17)(b)(3) වගන්ති යටතේ යම් සාධන පත්‍ර සඳහා ඡායාරූප ලැබිය යුතුයි. මොනවාද ඔප්පු? විකුණු කරොප්පු, ත්‍යාගෝප්පු, හෝමාරෝප්පු සහ අන්තිම කැමැති පත්‍ර. So there are a couple of things to be done. මොකද්ද කළ යුතු මූලික දේ? 1. ඉඩම් කන්තෝරුවේ පොත් පරීක්ෂා කර බැලිය යුතුයි. 1. 2. ඉඩම් කන්තෝරුවේ පොත් පරීක්ෂා කළ පසු දෙවෙනි කාර්යය තමයි ඒ පත්තිරුවේ අවසාන පත්තිරුවේ සාධක පිටපත් ලබා ගත යුතුයි. I need not tell you, when you are going through a title, you have to go through the title for 40 years. That's a different issue. Here the mandatory provision, that's also mandatory, but I am telling about the salient feature. 1. පත්තිරු පරීක්ෂා කළ බැලිය යුතුයි. 2. එහි අවසාන පත්තිරුව ලබා ගත යුතුයි සාධක පිටපත. 3. ඒ අවසාන පත්තිරුවේ ඇති මුල් ලියාපදිංචිය මේ නම ඔප්පුවේ සඳහන් කළ යුතුයි. Then the next one is having done that, signature beside or above left thumb impression there. 31(17)(b)(3) වගන්ති යටතේ සාධන පත්‍ර 4ක්. අන්තිම කැමැති පත්‍ර, හෝමාරෝප්පු, විකුණු කර සහ ත්‍යාගෝප්පු සඳහා. එහිදී තව මූලික දෙයක් තමයි අත්සන් කළ යුතු පාර්ශවය වෙනස් වෙලා තියෙනවා. In regard to a deed of gift, we know very well it is donor and the donee. Now in the deed of transfer, now we have introduced a new one. What is that? Seller and the purchaser. Both have to sign. Then we know very well, in regard to the exchange, there are two parties. In regard to the last will there. So the next question that I'll give you in chronological order. Now we are executing a deed. Number 1, get the signature. Number 2, having got the signature, beside or above finger, thumb impression. Then the next one is in regard to 4 categories of the deed. What are the deeds? Deed of transfer, deed of exchange, last will, and gifts. You have to get the parties' photograph affix. Now, for example, it is deed of transfer, seller, and the buyer. In regard to a deed of gift, donor, donee. In regard to exchange, both parties. In regard to a last will, not the beneficiaries, only the executor. Now, next question, everybody says, where to affix the photograph? Get a clear page where, having time that, I mean, if there are enough space, you will always have to keep space or margin for the signature, there you affix. What do you say there, having affix? Like how you certify a passport photograph. This is the photograph of so and so. Don't write on the, like what you do for the passport, don't write on the photograph, above the photograph. Say, may දැක්වෙන්නේ අහවල් පුද්ගලයාගේ ඡායාරූපය බව සඳහන්. Then having done that, what have you got to do? You have to put your signature, you sign. Then having signed, what have you to do? You have to put the seal. Did you get it properly? A, get the signature. B, get the thumb impression. Then if it is falling within the category of these 4 deeds, affix a photograph. When you affix a photograph, above the photograph, I say, this is the photograph of so and so. Then below that, you have to put the signature. Then thereafter, you have to put the seal. I had experience recently in Kaduwela land registry. I attended a deed for registration. Rejected. Chaya rupe moona penne. So I asked my clerk to speak to the registrar. I called the registrar and asked, මොකද්ද ප්‍රශ්නේ නෑ මහත්මයා මේ මූණ පේන්නේ මට කරුණා කරලා කියන්න පනතේ කොතනද තියෙන්නේ මූණ පේන්න ඕනේ කියලා. දැන් කවුද කතා කරන්නේ? So I said I'm so and so. I said මේ සර්නේ පනතේ this is problem. මම නෙමෙයි කාටවත් මේක කරන්න එපා. So the question is obviously to avoid that situation. Once you put a signature, I don't think we scribbled in our signature. It's a short signature we put. So be careful because now the land has a tendency to reject these, not to accept these. Right. So that as time is there. So that is next one. Then the other issue is executing. Yeah. Then thereafter, in addition to the signature, thumb impression, and the photograph of the parties, notary should also affix a seal and should certify the photograph in the such person. And also, notary should keep national identity card, passport, driving license attached there. So notary must keep, because if you can remember earlier section 31, subparagraph 9, we had a lot of problem. Why? You can execute a deed, either you should know the executant or witnesses. Take a this is 1907, not today. So look at a common sense situation. Who comes to us? The buyer. We don't know the seller. What do? We can't tell that man to bring two people and come. He comes, we try to get now quick buck. We get our clerk or a peon or a junior or driver. And what do you say to safeguard yourself? The executor not known to me, known to the witnesses. If something goes wrong, you are through, the poor staff is gone. So even recently, a very well-known, I don't want to mention the well-known notary who has completed 50 years in the bar, who has even written books on conveyancing, was charged. And indictment served, didn't go far, within 6 months he passed away. Similar situation, because of this section, he has got his son and the driver to sign. Unfortunately, deed was challenged, he was indicted. So you have to be very careful. But to avoid that situation, now we have brought an amendment to safeguard notary. New section 31, subparagraph 9, I have used the word not executor. Executor means one of the parties, either seller or the buyer. So definitely you know. Surely you should know that. So now that problem won't arise to you. So to avoid it. So in terms of new section 31, subparagraph 9, one of the executor, either seller or the buyer. Number 2, witnesses. I have gone a step further. Or if you can identify the executor or the party through the photograph, through the identity card, passport or driving license, that will suffice. There is no problem. Now I have taken a lot of safeguard to protect notary on that. So that is that. Now let's come to the second point. Executing a deed based on a power of attorney. When notary is executing a deed based on a power of attorney, in terms of section 31 subparagraph, notary should annex a certified copy of the power of attorney to the original power of attorney obtained from the registrar general there. Now back again, what is the meaning of this? You do a deed based on a power of attorney. Can't you annex the original? Now these are the problems we have. So even if you do have original, when you are using a power of attorney and showing a deed of transfer, you can't annex the original. I had a problem recently, I have annexed the original. මහත්යනේ නීතියදී බලන්න කොහොමද මේවා කරන්නේ මම කිව්වා මේක මේ සහතික පිටපතට වැඩිය වටින දෙයක් මේක මේ සහතික පිටපත එකතු කරන්නේ මුල් පිටපතේ no. So these are the things to be changed. Now imagine you register a power of attorney, you get it after registration. Now you have to apply for a certified copy. Until the certified copy comes, you can't do the deed. So anyway, that's a law. Whether you like it or not, you have to follow. Then the second one. When a notary executing a deed based on the power of attorney, he must comply with the provisions of the power of attorney ordinance, must examine the relevant volume. That's another problem now. If you are doing a transaction based on the power of attorney, you must go to the registrar general and see whether that power of attorney is genuine, valid or still in force. කිසියම් සාධන පත්‍රයක් attorney බලපත්‍රයක් මත අත්සන් කරනවා නම් කළ යුතු මූලික දේ මුල් ඔප්පුව එකට අලවන්න බෑ. මුල් attorney බලපත්‍රය අලවන්න. සාධක පිටපත ලබා. දෙක ඒ ඔප්පුව ලියා සාධක කිරීමට පෙර registrar general කාර්යාලයේ පරීක්ෂා කර බැලිය යුතුයි අදාළ attorney බලපත්‍රයේ තාම බලංගුද නැද්ද. You have to check. So you can jack up your fees but do your job properly. So you can say now new law has been brought in, අලුත් නීති කරලා තියෙනවා ඉස්සර වගේ එකපාරට ඔප්පු ලියන්න බෑ. So you can increase double or triple, but you do properly, Otherwise, you will be ending up at me because complaint will come to me. Then next one. In addition to the inspection of the Registrar General Office, the notary should observe section 3115A of the Notaries Amendment Act, should obtain a power of attorney called affidavit there. Now, all this time what we did is, we got an affidavit from the attorney for the purpose of registering the power of attorney. No. Now, in addition to that, you have to preserve a copy with you. For what? To say that this attorney is saying, these are all to safeguard notaries I have brought in, I must say. Attorney says, the power of attorney is still valid, enforced, not cancelled. So that is a notary's protection we have to say. Then the next one, when a land transaction taking place based on a power of attorney, notary should ascertain whether said power of attorney has a special power of attorney complying with the requirement section 3 to A, B and C, and also power of attorney should author. Now, next thing is, if a power of attorney is a general power of attorney, you can't execute it. It has to be special. If you can remember the people who go to Mecca, they suddenly give a power of attorney and go. When they come from Mecca, they say all the properties have gone. So you can't. As a notary, when you execute a deed, it should be a special power of attorney. Power of attorney not only should be special, it should specify and say, for the purpose of sale of this property. And there must be schedule, meets and bounds. Bound, everything has to be there in terms of law. Now the next question is, you also have to check. Now, power of attorney is given for the purpose of signing the deed. But there are very often attorneys play out the principle, collect the consideration. Attorney balapatrayak දීමේදී පැහැදිලිව සොයා බැලිය යුතුයි. ඒ attorney බලකරුට ඔප්පුව අත්සන් කිරීමට අමතරව ඒ ප්‍රතිෂ්ඨාපිත මුදල ලබා ගැනීම සඳහා වගන්තියක් තියෙනවා. Power of attorney will say, I hereby authorize so and so to sign, execute, all that. Whether there is any clause to say collect money on his name, on my behalf means to him. So ensure always when a deed is signed by a power of attorney, the consideration should be paid to the principal, not to the attorney. Very often attorney misuse. The lawyers are, notaries are unaware and say, no, he has authority to sign, collect money on his behalf, not in his name. So you have to be very careful. Look at that clause very specifically. I said, whether such power of attorney authorizes the power of attorney holder only to sign the deed, or whether it authorizes to collect the sale consideration in the name of the attorney. That you have to check. Now, the next page, I'm doing it. As per, now, the other thing is, now, in terms of the land, Acquisition Act, foreigners can't buy property. Foreigners can buy only condominium. Earlier, it was above the 4th floor, now it's from the bottom, you can buy. But the crucial ingredients is, when a foreigner is purchasing a property, the money should come from inverted remittance. Through a Sierra account, money must come from abroad. You can't have money somebody's black money or somebody's transactions can't be used here. So when a foreigner is purchasing a property, when you are doing a transaction, you have to ensure, first and foremost, whether money has come from an inverted remittance, from a proper channel. I think Dilip Paris and I had an interesting case. You know the case what I am referring to. So, proper channel. So, when money doesn't come in through a proper channel, it's an illegal. Why they say money should come through a proper channel? Because in case, one fine day, if that foreigner want to sell it, he can take with the central bank, exchange control permission, he can take. So, if you are executing a deed in regard to a foreign national, ensure whether the money has come inverted remittance, just not invert, it's a Sierra account, proper account. Then, very often, foreigners, people who are living in UK, USA, Canada, London, all the places, they buy properties. When they buy properties, what do? They are actually not dual citizens. They are foreign nationals. But they keep the identity card. Generally, I think subject to correction, I'm not familiar with it. Generally, when you are a citizen of another country, you have to surrender the identity card. They don't surrender. So they misuse the identity card purchased properties, but they are abroad. So somebody buying the property for and on behalf through the power of attorney holder says, no, here is his identity card. He may be having identity card. That is not a conclusive proof to show he's a Sri Lankan. So if for your safeguard, take an affidavit from the attorney to the effect to say the so-and-so, the purchaser is a Sri Lankan, he is a holder of national identity card number such and such, then you will get and the particular attorney indemnify and absolve you from all liability. Otherwise you will get into a difficulty. Now the next one, when a transaction is done by a limited liability company. So when a property is sold by a limited liability company, when a seller is a limited liability company, first and foremost, notary has to ascertain memorandum and articles of association who is authorized to sign on behalf of the company. If you take a limited liability company, either it could be two directors. සීමා සහිත සමාගමන සමහර අවස්ථාවල අධ්‍යක්ෂකවරු දෙදෙනෙක්. එහෙම නැත්නම් අධ්‍යක්ෂක සහ ලේකම්. එහෙම නැත්නම් බලයලත් නිලධාරී, authorized officer. So what are the documents to be looked into? Number 1, certificate of incorporation, සංස්ථාගත කිරීමේ සාතිකය. Form 1, registration of a company. Form 15, annual return. Form 20, director's detail. Then the next question is, if any company is selling their only asset, if it is above 50% of the shares of that company, apart from these documents, apart from a board resolution from the director, you have to get the shareholders resolution. කිසියම් දේපලක් විකුණු ලබන අවස්ථාවක ඒ දේපලේ වටිනාකමට අනුව අදාළ සමාගමේ වත්කම් වලට වැඩිය 51%කට වැඩිය වැඩි නම් ඒ අවස්ථාවේදී කොටස්කරුවන්ගේ සම්මුතියකුත් ලබා යෝජනා සම්මුතියක් ලබා ගන්නවා. You have to get this shareholders resolution. The next is, if a company is selling with that, then similarly, if a purchase a limited liability company, notary has to check all the above documents, and notary must check whether as per an article, company has a right to acquire the property. That's also very important. So you form companies, if the company doesn't have any clause in the articles to the effect whether the company can acquire property, you can't buy. Why? That is not envisaged in the company. So these are the important things you have to see in the notary's ordinance. Now let's get back to the second one, Power of Attorney Amendment Act. The salient features, Section 3, subparagraph 1A of the Amendment Act, registration of power of attorney has been made mandatory as the registration of power of attorney was optional. So earlier the law was power of attorney is not mandatory. If attorney so decides, he can. Now it is mandatory. Having been made mandatory, if it's a local power of attorney, within a period of 1 month. If it is a foreign power of attorney, within a period of 3 months. Now, as per Section 3(1)(b) of the Amendment Act, if the power of attorney is executed in Sri Lanka, same to be tendered for registration within a period of 1 month. However, if the power of attorney was executed in a foreign country, same to be tendered for registration in Sri Lanka within a period of 3 months from the date of the execution. So, if it is a local power of attorney, 1 month. If it is a foreign power of attorney, within a period of 3 months. Now, who could certify a power of attorney? Then Section 3(2)(1)(b), it says who can do a Number 1, an ambassador. Number 2, high commissioner. Number 3, diplomatic officer. Number 4, consul office. Number 5, person authorized. When you say person authorized, it can be solicitor, it can be attorney, it can be a notary public, depending on that law, country, who is authorized to do. Then the next one, as per Section 3, subparagraph 3 of the Amendment Act, if it's a foreign power of attorney, now another mandatory thing, but you have to get 2 witnesses. You have to get 2 witnesses with the principal to go and sign. Addition to that, at the time of signing, the particular person must certify the bio page and say, this is the photograph of mine, so and so. Now look at back again the practical problem. Say a housemaid who is in one of the foreign country, travel miles and miles away to see an ambassador or a consul general, and you have to take another 2 witnesses. I'm sure they are not going to come for nothing. You have to pay them. Now, these are difficulties, envisaged by the people by the act there. So, if it's a local power of attorney within a period of 1 month, if it's a foreign power of attorney within a period of 3 months, and who are the people can be certified? Ambassador, High Commissioner, Diplomatic Officer, Consul Officer, a person authorized. The person authorized could be lawyer, or a solicitor, or a notary, or some countries even commissioners of courts. So depending on that country law. Then, if it's a foreign power of attorney, they have to go before one of those authorized officers, certify and say the bio page, this is the bio page of mine. Now, if they are not certified, Registrar General Office refuses to register. Then also you have to say that 2 witnesses have to sign. Next one, Section 3, subparagraph 2B(c) of the Act. If it falls within the Section 2, prevention of fraud, or in sale of a property, as I told you earlier, that particular power of attorney should contain the entire schedule. If it's a special power of attorney, in regard to a sale, metes and bounds, extent, all the details, everything has to be included. Then Section 3, subparagraph D of the Amendment Act, there were earlier irrevocable power of attorney. Avalangu kala nohaki attorney power. Now we have done a change, no longer irrevocable powers of attorney. It has been only state. Only a state can. There is a lot of aho by the banks. I think this may be changed. Why we specifically brought this irrevocable power of attorney there? By making use of this irrevocable power of attorney, so many fraudulent transactions are taken place. I'm personally aware. Well-known financial companies like lending institution, one particular case where a property was worth 10 billion. 10 billion. The person has borrowed only 500 million. And there is a clear document to pay, say it has to be paid or no before 6 months. Failed. No sooner it was failed, not even 1 week from the 6 months lapse, made use of the irrevocable power of attorney, property transfer. Action 5, person got ejected. So there are a lot of financial institutions not approved by the central bank, lending institution misusing. So now, of course, bank has created a lot of issues saying that they can't have a banking transactions owing to that. There may be an exemption in regard to the bank. Then the next question is validity of a power of attorney. We have said it's for 5 years. That again, we have made a proposal to delete the period because there is no point of having 5 years for the reason, not like earlier, now the powers of attorney could be cancelled easily. So the next case, as per Section 4, subparagraph 1 of the Amendment Act, principle of any power of attorney are there. So when a power of attorney is given, earlier it was very cumbersome. According to the prevailing law, if you want to cancel a power of attorney, gazette notification, paper notification, long process to go through. Now it's nothing. We have made it very simple. Notify the other party of such intention to revoke the power of attorney. Execute a notarial document declaring his intention to revoke the power of attorney, specifically expressing his intention that the power of attorney holder is not to act under said power of attorney, submit that power of attorney for registration. So basically, if you want to cancel a power of attorney, it's very simple now. You give a power of attorney today to somebody, you want to cancel it, you inform him by letter, I do not intend for you to continue as a power of attorney holder, I am going to cancel. Do a document, send it for registration, it will be registered in the same place, the cancellation. So it's so simple, it's not that difficult because a lot of people have misused. Now the next question, 4.2, very often the questions are posed. Now say for example, if a person is in England, he has given a power of attorney and he get to know on a Friday, late person is going to misuse the power of attorney, going to sign a deed, real transaction will say 100 million, he is telling the owner, particular owner, no, I am selling it only 50 because he has a deal with the seller and the purchaser and him. So in a situation like that, what can you do? You can't go through all the procedure. So we have very simplified the procedure. What's the procedure there? Section 4, subparagraph 2A, if a principal wishes to revoke a power of attorney with immediate effect, until such documents are prepared, either principal or his attorney could notify the intention to revoke the power of attorney to Registrar General. If you are living abroad, either you can send an email or fax or through a lawyer in Sri Lanka, you can write a letter and say, I am living in England, I am the principal who gave the power of attorney number such and such, date of such and such, attested by so and so notary public. I do not intend this particular attorney to continue with this power of attorney and do work, make a note of that. So it's like even regard to a vehicle, where we have an issue, we write to register of motor vehicle and say, look, so and so there is a family dispute, and therefore any document come pertaining to the registration, don't register. So similarly, if a power of attorney is given by a person who is living abroad, and if he is unable to come to Sri Lanka or do anything, either he can directly send an email to the Registrar General, or through a lawyer he can write a letter, say that I intend to cancel this, and any transaction come, don't register. So like a caveat, it will be endorsed there. But of course, having done that, you can't sleep over maximum 3 months. Within 3 months, you have to take steps to cancel. If you don't cancel, that particular hindrance or the block will be removed. So basically what I am trying to say is, not like earlier, now the power of attorney could be easily cancelled. A, by notifying the attorney. Either way, if the attorney is not interested, he can sign the principal, tell the principal. So inform the attorney, do a cancellation, register. If somebody living abroad want to cancel forthwith, all what you have to do is inform the attorney, I intend to cancel, and send a document to the Registrar General either directly or through a lawyer, and that will be recorded. In case if any transaction goes through, that won't be valid. Why? Already notified. Next one.
Excuse me, sir. That may amendment take බලාත්මක වෙන්නේ 2022 ඔක්තෝබර් 25 නම්
අත වශයෙන්ම නොවැම්බර් මාසේ 4 වෙනිදා ඉඳලා.
ඊට කලින් ලියපු ඇටර්නි ප්‍රවස් මේ විදිහටම කැන්සල් කරන්න පුළුවන්ද?
දැන් පනත ආවයන් පස්සේ පනත තියෙන විධිවිධාන අනුව පුළුවන්. මේක අතීතයට බලපාන පනතක් නෙමෙයි, ඉදිරියට බලන කරන්න පුළුවන්. You can. ඊට මම තවදුරටත් පැහැදිලි කරන්න මේක ඊට පස්සේ අහන්න. ඊළඟ another salient feature of the act is Section 8A Amendment Act, when a power of attorney has been executed prior to the incapability. Now, if a power of attorney has been done prior to this law came into operation, if that had been sent for registration, not registered within a period of 6 months, now that is over, because power of attorney came into operation on the 4th of November, although speaker signed on the 25th, came into operation on the 4th. So therefore, that particular period is over 6 months. The second is very important question that he raised. If a power of attorney has been given, say for example, irrevocable, say for example, more than 5 years, still it's valid. Why? Prior to that came into operation. So the transitional provision very clearly says, if a power of attorney has been given prior to the act came into operation, it could be irrevocable, it could be no period, whatever, that's valid until it is cancelled. And also, වතුමාගේ ප්‍රශ්නෙට උත්තරේ මේ පනතේ මේ විධිවිධාන අනුව කලින් දුන්න කියන්නේ 2022 නොවැම්බර් මාස 4 වෙනි දිනට කලින් දුන්න ඇටර්නි බලපත්‍රයක් මේ පනතේ විධිවිධාන අනුව අවලංගු කරන්න පුළුවන්. Then next one, Section 8C, every power of attorney executed prior to the legal amendment, so that is when it has been submitted for registration, pending, it can be registered. So that's but now let's go through it. I know time is the issue. The wills ordinance. Yeah. Section Wills Amendment Act. Section 31, subparagraph 20H of the Amendment Act. When executing the last will, following to be followed. In the attestation of the will, notary must say without whether the testator is in a good, sound mind and condition. So generally we do. Now there is a specific provision has been made in the attestation clause that section 31, subparagraph 28. He must say that the notary, notary of course must be in sound mind, otherwise he can't attest. The executor has to be in sound mind. So the important thing is when you are doing a last will, the person's condition is very important. So the best thing to do is you have to get best is a doctor as a witness. You can, because you know very well, maybe challenge. Second thing, if you can't get, and if you do have any doubt about the mental or physical condition of the person, better you get a medical certificate to the effect. And the other thing is very crucial when you are getting witnesses. Get somebody who is reputed. because you get witness. Now say for example, you get a person who is 60 or 70 years old, you get witness who are 90. Obviously, before that, other people have gone 6 feet under, so you can't prove the will. So number one, get the person, if possible, best is enough. If a person is bedridden or in hospital, get the medical certificate, at least to show that he was in a proper state of mind to sign. And also witnesses, get somebody who is reputed in the society. Otherwise it is challenging. Then the other thing is, now in regard to the another new one we brought in, you have to make, now last will is a document, it's only 2 copies, original and protocol. There is no duplicate. But then you have to maintain a register. What we do, the maintaining the register is we just say number. Now we have brought a new thing, you have to put the testator's name. Why? Very often, I have done, why should I tell you like, sometimes we miss a number. We say last will. So sometimes people are doing some fraudulent transaction, they say last will. There is one instance I could tell you, very reputed firm, a lady, very senior lady lawyer worked there. The company is lending money, so they do short mortgages, 5 million, 10 million, never go for any litigation, and big amount of money, then they lend it. So what this lady lawyer did is, she collected the mortgage bond fees, the stamp duty, never sent a single deed for registration. Why? Nobody come and question you within 3 months, 2 months. Unfortunately, one particular deed was, the money was not paid. So that client came and said, Madam, can I have the number? She gave the number. When you go to land regency, that lady last several years have said only last will, number will, nothing. All the stamp duty, she was indicted. I don't know what happened to the case, the very senior lawyer who happened to be a batchmate of mine, I don't know what happened. All the deeds are last will. So of course, story is she has acted in collusion with one of the directors and they have shared the money. Massive amounts, like 25 million, 50 million. So imagine a stamp fees, putting 1% of the thing. So to avoid that, now we have said no. You have to say who is the testator. So in case a deed is challenged, from your book we know very well you have done a will on that day. Next one, the age limit of the who can execute a will in 1907, law has taught women are more mature than the men. So in 1907, Act says men to do a deed, will, he has to be 21. Woman is 18. Of course, after 106 years, we have now become little more matured and now 18 and 18 for both. Then the other crucial thing is section 2, subparagraph 2, we have it is there in that, but we have specified testator could disinherit anybody and give it to anyone. The very often the clients are coming and consulting and say, look sir, my husband has left the will, everything to a mistress or some other of his friend or someone there. So what can I do? So I said, look, during his lifetime, if you had looked after well, he would have never written to a mistress. Of course, answer to your question, section 2, subparagraph 2 specifically gives the power to disinherit. So look after the men very well, then you will get your property, not otherwise. Section 2, subparagraph 2, it says, testator has absolute right to disinherit any child, parent, relative, descendant when executing a will without assigning any reasons. So be good, then you will get your property. Next one, the very often, another mistake people make, joint last wills. Now say for example, X and Y both jointly execute a will. X says, if I die, all my property should devolve on Y. Y says, if I die, all my property should devolve on X. And said, if X and Y both dead, it should go to children. Now the question arises, very often people make mistake, even senior firm, X died. They think by operation of law it goes to Y. No. Because some of the argument put forward, there is one will, why should be proved twice? You have to. X owns a property, Y owns separate property. If X died, that particular property will go to the estate. It is a testate estate. So you have to file a testamentary case, prove the will of X, then the X's property will devolve on Y. When again Y died, again you have to file a case. So in short, in regard to a joint will, හවුල් අන්තිම කැමැති පත්‍රයක් ආශ්‍රිතව X හා Y යන පුද්ගලයන් දෙදෙනෙක් X කියන පුද්ගලයා මිය ගියොත් ඔහුගේ ඔයාගේ දේපල Y ට යන බවටත් Y මිය ගියොත් X ට යන බවටත් සඳහන් කරලා තිබොත් X මිය ගිය අවස්ථාවක X ගේ දේපල රික්ත වර්ණය වෙන්නේ නැත්නම් පැවරෙන්නේ ඔහුගේ බූදල ආශ්‍රිතව බූදල් නඩුවක් පවරලා අන්තිම කැමැති පත්‍රය ඔප්පු කරලා පොල්මංකාර ඔප්පුවක් ලිව්වන් පස්සේ not otherwise similarly why so point what I want to stress is if there is a joint last will the will has to be proved twice why undoubtedly it is one will but two separate properties X died you have to file a testamentary case and ensure that the property devolve on Y. If Y die early, you have to do other. It will devolve now, even to go to the children. There must be a testamentary case and there must be executors conveyed. Otherwise, it won't come. So that's what I say here. 7.2. If a person leaves behind a joint will and dies, in such event, joint will has to be proved twice. Namely, when the two testators execute a joint will, upon demise of one testator, in such event, other testator or the other person has been named as executor or executor should institute to prove the will on the deceased testator upon the demise, second testator, and the person named in the joint will there. So it has to be filed twice. Then the next question arises, if somebody execute a will in a foreign country, maybe in Australia, in regard to property situated in Sri Lanka, what do? You have to file a testamentary action in that country, get the foreign probate. That foreign probate has to be received in Sri Lanka in terms of section 554U of the Civil Procedure Code. කිසියම් පුද්ගලයෙක් යම් කිසි විදේශ රටක මේ යන අවස්ථාවකදී ඔහු සතු දේපල ශ්‍රී ලංකාවේ තිබේ නම් ඒ දේපල ආශ්‍රිතව අන්තිම කැමැති පත්‍රයක් ඒ රටේ ලියා ඇතනම් ඒ අන්තිම කැමැති පත්‍රය ඒ රටේ ඔප්පු කළ යුතුයි. ඔප්පු කළ පසු ඒ විදේශීය probate බලපත්‍රය ලංකාවට ගෙනාවන් පස්සේ එය නැවත මුද්‍රා තැබීම සඳහා සිවිල් නඩු විධාන සංග්‍රහයේ 554 U වගන්තියේ විධි විධාන ප්‍රකාරව නඩුවක් ඉදිරිපත් කරනවා. But there won't be cumbersome. It's only very quick procedure. Only once you have to publish in the newspapers. The rest of the process will quick because there won't be any contest. So those are the matters pertaining to the Wills Amendment Act. Now the final one in regard to the registration of document ordinance. Section 32 subparagraph 1 in regard to caveat. What do you mean by caveat? Means a Latin term. Caveat emptor. Buyer must be aware. Manatam ganum karu pravesam viyutu. So until the law came into operation, anybody can. Any person who has an interest in the land, and very often this section was used by the brokers. Brokers take the deed. If their commission is not paid, they go and land a caveat. To avoid that situation, now we have specified who can put a caveat. The person who can put a caveat, we have two things. Caveator means a person who has a right title and interest to the land or claim to have right title and interest to the land there. So the person who is a caveat, I'm not taking time as Dilip has to start, it has specified who is the caveat. So when you caveator, I have put all the detail, includes who are the person, body of person, beneficiary, lawful guardian, next of rent, all these details are there. So if you want to put a caveat, it has to fall into two categories. Number one, you must fall into the category of the interpretation of the caveat topic. Number one. Number two, you should have a interest. The person who has an interest in the land. A, he must fall into the category of a caveator. Number two, he must have an interest to the land. Then the person who has an interest to the land is being defined. Interest arising from like a condominium, even if you have an agreement to sell in regard to a condominium property, you have interest. So the children, kith and king, spouse, all those people have been specified. But having done that, still you can't put a caveat. What have you got to do? You have to get a certificate from a lawyer to say, I have perused the claim of this property. The particular person falling into the category of section 32 subparagraph 3(1) is falling into the category of a caveator. In terms of section 32(c)(3), he is falling into the category of a interest, and therefore I certify. If a lawyer certifies wrong, he gets into difficulty. So you have to be careful. So in regard to the caveat, the most important crucial thing it should fall within the definition. එතකොට කිසියම් පුද්ගලයෙක් caveat බලපත්‍රයක් caveat දානමක් ඉදිරිපත් කරන්න අපේක්ෂා කරනවා නම් එක ලේඛන ලියාපදිංචි කිරීමේ ආඥා මන්ත්‍රයේ 32 C එක වගන්ති යටතේ කේවියෝටෝ නැත්නම් කේවියට් කතානාකරු කියන අර්ථ නිරූපණයට වැටෙන පුද්ගලයෙක් වෙන්න ඕනේ. 32 C 3 වගන්ති යටතේ ඉන්ට්‍රස්ට් නැත්නම් සම බැඳීමක් නැත්නම් අයිතිවාසිකම් තියෙන ගණයට වැටෙන්න ඕනේ. and ඊට අමතරව ඒ පුද්ගලයාට එවැනි අයිතිවාසිකමක් තියෙන බවට නොතාරිස්වරයෙකු සාධික කළ යුතුයි. Then all the other details are there. Cancellations, I think I'm not going to deal with the time factor. And also, important thing is, as far as the caveat is concerned, if you land a caveat without any right, in terms of section 32, subparagraph 5, action can be instituted claiming damages. Thank you.